Hi everyone, I'm Ryan Orr. I'm a consultant with Cascade Employers Association. I, for a while, was an employment attorney, worked as an administrative law judge for the state, and now I do this consulting. So all my background has had a lot to do with employment law and these kinds of topics. So I have the agenda up here. You can see what we're going to cover, but I do always encourage people, please interrupt with questions. You don't have to wait till the end. I'd rather talk about what's going on with you or what you're thinking about as we go through it. And this is kind of an interesting time to be doing this because when I've done this training several times now, and we did it before, and all of them were before July 1. So that was kind of interesting because everyone was trying to figure out, well, what does this mean? What's going on? But we didn't really know what the practical effect would be at work. People hadn't been able to purchase recreationally in Oregon and use in Oregon, so we didn't know if it would become a bigger issue or not. Doing it now with everyone here is kind of cool because you've all probably seen the effects of this for the last 5 months or so. So things that you are seeing and your perspectives and questions you have about that, please feel free to ask as we go along. You see this agenda up here. Definitely want to talk about all the different laws that are in play so you know what they are. Talk about some of the issues with testing for marijuana and how that relates to the legal issues that we're going to talk about. And then we'll talk a lot about what employers are doing, what options you have, what some of employers' concerns are, and how to address those, or at least things to consider when you're making those decisions. I've got some sample policies for you, some sample letters that you can send out to your employees, just some things to look at and take home with you. Talk about what reasonable suspicion training is if you don't already know and how that relates to everything here. And then kind of what I was just talking about federal law. We'll look at where this might go in the future and then how that could impact your policies as we move forward. So starting with a little history. So marijuana had been illegal for decades. And then in 1998, Oregon passed one of the first, I don't believe it was the first state, but one of the earlier medical marijuana acts that made it legal for medicinal purposes. So kind of starting to soften those laws about it a little bit. There was no job protections written into the act, so that's a really important part as far as it relates to employment. And because of that, and because it's still being illegal under federal law, we got this Emerald Steel Fabricators case that came down several years ago. This was basically an employee who said, well, I've got this medical card and I've got a disability, and employers, you've got this thing called the Americans with Disabilities Act where you have to accommodate my disability. So I'm not saying accommodate me by let me come into work high, but I use this off-duty for pain or whatever the person used it for. So why don't you accommodate my off-duty use? The Oregon Supreme Court looked at that in that case and said, you don't have to accommodate it. Just really clearly said that. So that was the case there, and that's still the current law. That for disability law, you do not have to accommodate off-duty use outside of work. And the court basically relied on the fact that it is illegal federally there. So as the rationale for that decision. When that law passed, it passed by about 54%, and employees were still able to possess it or grow under it, or residents of the state. It's still in effect too, by the way. And you might ask, well, why does it need to be in effect if we have this new recreational law that just kind of opens it up to everyone? But there are different age limits. You have to be 21 under the new law. There's no age limit under the medical law. And the amounts you can possess and grow and things like that are very different. So there are still reasons why people might want to have a medical card. Fast forward to November of last year, and we passed Measure 91, legalizing it beyond medicinal use, and now it's legal recreationally. So, as I mentioned, you do have to be 21 or over, much like alcohol. You can have up to 8 ounces in your possession and up to 4 plants per residence. Allowed to possess in public up to 1 ounce, which is a pretty sizable amount if you've ever seen an ounce in a bag or had a, police officers, I know sometimes talk to people about that and demonstrate it, like, it's a fair amount. Maybe I'm making it a little bigger, but it's like more than people are gonna be using kind of in one sitting. So, it's interesting that they chose that amount. However, you can't consume it in public still. We can't take it across state lines because that's considered interstate trafficking, and that's still illegal federally, so there's no protections for that. And also interestingly, even though there was this big fight in Supreme Court case back when we passed the Medical Marijuana Act, there were still no job protections in this law. And that was specifically written into it, that using, specifically omitted from it, I think that even though if you're using, we're not going to create some special class or protection for people at work.
Question?
Yeah.
So, you're talking about the state lines, but what if, say, because we border Washington, and it's legal there too?
Mm-hmm. Yeah, even though it's legal in Washington and legal in Oregon, the act of transporting something across state lines is a federal issue, and so it's still illegal under federal law. Washington and Oregon police aren't going to do anything, but if, for some reason a federal, like a DEA officer got involved with that, that would still be an issue under federal law. That's a good question. Looking at what the current state of federal law is, we have this thing called the Controlled Substance Act that splits drugs into all these different schedules based on their medicinal value and their potential for abuse. Marijuana is considered a Schedule I drug, which means no accepted medical value and high potential for abuse. So they don't even, so at the federal level, and this is kind of an issue with the medicinal stuff, they say there's no medicinal reason for it. And that, I think that's important when we look at the Americans with Disability Act and federal law, because if federal law says there's no medicinal reason for it, how is that going to ever be considered an accommodation for a disability? I think that'll be a difficult argument to make. But as I was mentioning, they're looking at relaxing, or they're at least talking about it for the first time, relaxing it at the federal level, whether that would be rescheduling it to a lower schedule, so it could be prescribed and be legal federally to do that, or whether it just would be totally decriminalizing it. We don't know. People have different opinions on that. I do think it's pretty far off if there would be any changes, but it's something that is being talked about for the first time ever. Seriously talked about, I should say. Looking at other state laws like Washington, we've got 24 states that authorize it at some level for medical use. Not all full authorization, but at least some authorization for it. 4 states that now fully allow recreational use: Washington, Oregon, Colorado, and Alaska. Off-duty conduct laws are an interesting component to this. So I'll explain that for a little bit. In Oregon, we don't have one of these, but Oregon's a very blue state in terms of employment laws, so it wouldn't surprise me if we ever passed something like this. But Colorado has one. And so they've got this law in Colorado that says, if you're doing something off-duty from work that's legal to do, you can't be fired for that. It's very different from Oregon, where we're an at-will employer. You can fire somebody for any reason, ostensibly. I could teach a whole class about the limits to that. But technically we could, alcohol is legal, but if you didn't like that somebody drank off-duty, technically we could fire somebody for that. That is not the case in Colorado.
Brian?
Yeah.
Sorry to interrupt. Quick question. Is that codified in Colorado code, or is that as a result of this Coates Swedish network case?
It's codified in Colorado, and then this Coates case that I was about to mention was an interpretation of how that case interacted with Colorado legalizing marijuana for recreational use. Because the employee Coates worked for Dish Network, and they had a strict anti-drug and alcohol policy. He popped positive for marijuana, and he was terminated under that drug and alcohol policy. And Coates is sitting there saying, whoa, 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 it's legal recreationally, and we have this off-duty conduct law, right? I was just doing something that's legal off-duty. So this case came down several months ago, and the Supreme Court said, that's great. This is the Colorado Supreme Court. That's great, but it is still illegal federally. And there's actually lots of instances where something is a federal crime, but maybe not a state crime, or vice versa. And so they said, just because it's legal here, you know, this off-duty conduct law, the way it was written, just says it has to be legal, you know, and it was illegal at the federal level. Now,
So coach termination ended up staying.
yeah,
He was terminated, they couldn't, there's nothing to it anyway.
no, I mean, it went
Well, it was
through
just-
various
yeah,
appeals,
yeah.
but yeah, the Supreme Court basically said we were justified in
Yeah.
terminating Mr. Coates.
And
So-
just a real
Yeah.
quick item, I assume that statute was made in response to employers who didn't want their employees to drink alcohol off work. I mean, I would assume so. What else would they have?
Or,
That would be the instance where that substance is legal under both state and federal law,
yeah,
I guess.
yeah, no, I mean, I think I'm not sure, I'm not as versed in Colorado law, and I don't know the impetus behind this statute. It could have been we have something similar with tobacco use in Oregon, where lawful off-duty tobacco use is a protected class in Oregon. So I would imagine that whoever backed a law like that probably was a powerful interest group like that, like cigarette or tobacco and alcohol lobby, because yeah, they're the ones who want people to use their product and not get terminated for it. But that's just a guess, I don't actually know the history of it. So I mention it because we could see something like that in Oregon. It also could, the Colorado court relied very strictly on the language of the statute, which didn't really differentiate between federal and state law. We could draft something in Oregon that says, in Oregon, you can't terminate somebody for doing something that is lawful under Oregon law. And then we would probably get to a different decision than what happened in the Coates decision. But so, it would all depend on how those things are drafted and what the, who's who the interest groups are who are trying to influence that statute. But anyway, that's how that comes into play. But bottom line is we don't have anything like that in Oregon, and technically, even if marijuana was legal everywhere, at all levels, we're still at will employment in Oregon, and technically we could fire somebody for using marijuana off duty. I don't think it's always a good idea to terminate someone for doing things that are lawful and not related to their job, but we could do that, just like you could terminate someone for chewing bubble gum if you wanted. So any questions about the law? The laws at play here? Yeah.
I just have a question about, it's not what they're doing, it's what if you start losing clients or issues because of their.
Well, and that's a better justification for it, but not all jobs have that justification where somebody's out in public or representing, the company. And if it was behind closed doors and like a service level worker, I mean, we're kind of like, I think it would be hard to make that argument in that situation, but luckily, it's illegal, and then it's a really clear justification as the law sits now. Any other questions? Yeah.
Yeah, actually, I do. So let's say, because if you've got a no tolerance rule per se in your employee manual, call him. But in your employee manual you specifically state instant termination for under the influence during work hours. But you don't do drug testing and whatever they do in a personal way. But if you don't do drug testing as a norm, what's the wiggle room there for you to, if you think they're under the influence, but it's not a general practice?
I mean, I don't recommend doing that without a test, because you do have a proof. You've got your policy that says, well, we can terminate you for being under the influence, and then we don't have the test to back it up. Now, there could be some situations where someone is clearly impaired, and maybe you'd be pretty safe terminating them without a test. But for the most part, you want that scientific, reading to justify your termination if you're going to terminate someone for being impaired. And there are lots of reasons for that, but the big one that stands out to me is the Americans with Disabilities Act, because there are conditions that mimic impairment, and diabetes being like the big one that comes to mind. And if you terminated someone because they appeared impaired and they were diabetic, now we've just violated their rights and terminated them for a disability when we didn't test them and get that scientific proof. So I think that's a risky practice, and I think if you are going to terminate people for being impaired at work, you should drug test and get that test result.
Yeah, quick question, but doesn't the test for the pot as it stands right now, it just tests for the presence of it in your body, it's not
Yeah.
to show impairment,
True.
isn't it?
True, but we're allowed to have, I was gonna talk about that in a little bit, but
Sorry.
that's a great question. No, it's an important question. It plays into a lot of this because, you know, the testing for marijuana is, it's this test for a metabolite that's broken down and stored in your fat cells rather than the substance that actually impairs you. So, but you are allowed to have a zero tolerance policy based on what is tested currently. And I think, you know, if you were doing like a reasonable suspicion test where you say, hey, you're exhibiting some signs of impairment and we tested you and we've got this metabolite in your system, so you test positive. I mean, it is a legal termination, and it's a pretty safe assumption that they actually were impaired at work at that point, because you've got both sets of evidence that you're working with.
Is there testing on site then? Because
Test-
you really don't want them to get in their car and really influence, you go to a testing location.
Yeah, well, if you're testing, you should never do that.
Yeah.
And if you're gonna go somewhere, you should have somebody, like their supervisor,
Yeah.
drive them and escort
We always
them.
have a supervisor bring someone in, and as
Yeah.
far as reasonable suspicion, the other thing that we highly recommend is two people should say, I think you're impaired, not just one. I'm not picking on anybody, okay? So that's, if you can, if not, one's better than nothing.
Yeah, and their testing companies will do on-site testing, a lot of them will. Yeah.
We've kind of got a little tricky situation where obviously we have some CDL holders, so that's like zero tolerance.
Right.
It says in our policy zero tolerance, period, but especially with the CDL program, but, we were notified through some off-hours activity. The person basically Googled and found out this person worked for us and reported some technically illegal activity trying to sell.
Mhm.
Ouch. But yet we don't have reasonable suspicion to drug test him because he's not seeming impaired, but he's growing it, you know.
Yeah, that's
So
an
it's actually got
interesting
turned
case.
over- It's been turned over to, a different police department outside of our city because he lives outside.
I think that's a good way of handling it.
And-
I mean, the issue whenever you're taking any action is that you have good evidence to support what you're doing. So like, you know, an anonymous phone call that says, I think this employee's growing.
Well, it wasn't anonymous.
Okay.
It was-
Well, the fact that it's not
Facebook
anonymous
posts
helps.
and
Yeah.
all kinds of stuff, but.
You know, and if
But
you
the
had.
scary thing though is he's a CDL holder, so in the meantime of while this whole investigation's going on, which could take quite some time,
Yeah.
he's still working. And
Well, you could, yeah, I mean,
it's hard to,
you know, and reasonable suspicion testing is kind of its own subject, but it requires knowledge of current impairment, so that is, you're right, you wouldn't really ask for a reasonable suspicion test there. I think, you know, I mean, there's different ways you could handle that, but I think it is smart to let the legal system kind of play out there and the evidence to be gathered in that way, because you don't have, you know, if he wasn't possessing it or growing it at work, where you actually witnessed it, you don't have the best evidence. But sometimes administrative leaves are appropriate there, you know, and not terminating someone, but, you know, we are,
yeah, we're not having termination, we need
Yeah.
to
you know, we might be wrong, but we're just so worried about the risk of the driver that we're gonna put you on administrative leave while we let this process play out. That's a possible way of handling that one. Yeah.
This is interesting because I always wonder, I mean, I've done some research, I'm not a marijuana user myself, but I've done some fair amount of research on it. And virtually there have been 0 deaths reported as a result of people smoking marijuana. And alcohol, on the other hand, is huge. And that's something that is, I'm here to learn more about this because of my job, but I also wanna know, like, what, if you suspect somebody, I'm more concerned about people drinking alcohol and coming to work because of the levels of impairment that are involved with that. Is there legally any testing that can take place at work?
Yeah, I mean, there's plenty of testing you can do at work.
That's
That's
for all-
legal,
okay.
yeah, if someone comes into work impaired. As far as the difference between alcohol and marijuana and the justification for it, I mean, I have heard that statistic as well, but that's the statistic about, like overdosing on the drug, versus.
No,
right-
this particular one wasn't, but go ahead.
Well, that's, I mean, that's where I've always heard that statistic cited, because I think what most employers are worried about is, whether it's alcohol, marijuana, cocaine,
Yes.
anything. You're coming into work impaired, you're
Yes.
working with heavy machinery.
Right,
You're driving.
exactly.
And there are lots of cases where people have died because they were under the influence of marijuana driving. And there are recorded statistics that, so yeah, overdosing on the drug itself, you're right, there aren't. But generally, we're not worried about someone overdosing at work.
Well,
That
no,
could
not,
happen.
this wasn't about
Yeah.
overdosing, this was about from use or causing death
Mhm.
from use.
Yeah, well, if it was talking about causing death, I would dispute that statistic, because I've talked to police officers who get the drug and alcohol test from accidents, and there's
The alcohol
plenty
is
that
definitely.
have marijuana on board too. Yeah, lots of them.
Well, there was the one all over the news about the girl last year trick or treating, who got killed
Yeah.
by marijuana.
Yeah, I think there were a couple cases that made big news right after the law went into
Yeah,
effect.
yeah.
There's usually multiple substances on board, marijuana often being one of them,
More
so,
knowledge, but even especially these people are that, like, freer to use it.
yeah, more access now, absolutely.
Sure.
But even prior to the law, it was on board a lot, as the police officers say. I wanna keep asking your questions, but I do wanna kind of jump into some of these specific questions, because this is, I think, what most people are curious about when they have come to this training. And just what are most employers asking, and what are some of the different ways that we can address this issue? The first one, and sometimes this just shuts down the inquiry for most people, where this is all I really needed to know, so thank you. You can leave it, that's you. But can I enforce a zero tolerance policy with respect to marijuana? And that's clear. Even though the law changed in Oregon, you can still do that. It's still illegal federally. We can be zero tolerance across the board. And no job protections written into the law, and still illegal federally. So that's okay. The questions that I get, well, actually, let's look at this one first. Alcohol is legal, so how is marijuana any different? Well, yeah, alcohol is legal under both sets of laws, while marijuana is not, and the testing is different. Our alcohol test for blood alcohol content, that actually can be tied to present impairment. What, the blood alcohol that's in your system, you blow a certain amount, we have, defined by law what per se impaired means, at least while driving, it's 0.08. Marijuana doesn't test that, because we're not testing the active chemical that causes people to be impaired. So it is a little different. It stays in your system a long time. There are researchers who are looking at this problem. One guy at Washington State in particular, who's developed all this crazy testing for like bomb components and things that TSA uses. He's really looking and trying to find a way that's a breath test that would be able to test for current impairment of marijuana. I'm sure it'll be developed at some point, and if it does, that will kind of change the game in this realm, because I do talk to people who are like, if it's legal outside of work and they're not coming into work and it's not affecting their work, I don't really care. But what those people are struggling with, especially the ones who have safety sensitive jobs, is I can't tell the difference, I don't have that test that tells me if they're impaired now or if they were just, partying on the weekend. I don't care about the weekend, but I care that I can't tell the difference. And so I'm gonna stick with my zero tolerance policy for now because I can't tell the difference. And I see a lot of people doing that because of that problem. But if the testing gets sorted out, I do think it will give employers more options in that regard. This is an interesting chart that my boss found. We've got these positive marijuana tests just plummeting, but then you see the refusals are jumping through the roof, which is, I thought was kind of an interesting stat. I think what Jenna found when she researched this is that testing companies have basically become a lot more sophisticated in terms of being able to pick up things that adulterate a urine sample or that can mask the presence of marijuana. Whereas, in years past, people were coming up with these products that you could use that could kind of fool the test. But, it didn't take long and testing companies caught on. And then the people who were using those products caught on too. And now we're seeing a spike in refusals because they know that there isn't some way to cheat the test. So this is probably other than that first question where people are calling to say, hey, can I just keep my zero tolerance policy? I think this is probably the next biggest question that I've got is, I've got these retention concerns or recruitment concerns based on, whether it's my industry, my location. I know people are gonna be using to some extent, so how can I realistically enforce a zero tolerance policy? I'm not gonna have any employees for certain positions or in certain areas. And I think that's a pretty legitimate concern. So there are plenty of options that people have and that I've worked with people on, one of which is not doing pre-employment testing. And I think there's a decent rationale for that, right? They're not at your work working with heavy machinery or driving a forklift. They haven't been subject to your policies yet. And it is legal recreationally at the state level, so maybe we want to be a little flexible with them and not enforce it with respect to marijuana pre-employment. And I think that's a reasonable way of doing it. The downside, I think, is that you become known as that place that doesn't test, and I think it, over time, could change the type of people who apply for you for certain positions. But other than that, I don't see a huge issue because there's no safety concerns, they haven't been working for you. It might just change the type of applicant flow you're getting once people know that you're someone who doesn't test.
Well, right now, you can't pre-employment unless it's for a safety sensitive position anyways, right?
No, you can
Yeah, you can
test
test.
pre-employment, yeah. I mean, you could just have
I
a.
guess it's an abundance of caution with that whole case that came down with the library page and I think if the Supreme Court says that you shouldn't be tested for drugs because it wasn't part of it, I don't know.
I'm not familiar with that case, at least not off the top of my head, but I mean, I think there's still a decent argument for testing even in not safety sensitive positions because drugs influence production too, how clearly you're thinking, and even if you're just kind of at a computer, it can still influence your production and performance at work, and it is okay to do pre-employment testing across the board, yeah.
Not only is it okay, it's probably a really great idea because sometimes not only do you stop having this little clique of users that influence other people and actually sell to some of your other employees, so that gets to be a bigger problem for you than that you have a problem on your hands. Not been on the front side of the can.
Yeah, so it's okay to do is the bottom line, but some employers, maybe we won't do it for marijuana. The test will still show you the marijuana result, because it's just part of the standard panel, but you could choose not to take any action on it and deny employment if it comes up positive for just marijuana. Another option, just doing reasonable suspicion or post-accident testing. I do have some employers who say, well, I don't care about what they're doing on the weekend, so I just want to know, if they're actually coming into work impaired, that's when I won't test, or if they cause an accident. I mean, I understand the reasoning behind it. There are definitely some downsides. What might be the downside of only doing those types of testing? It's a little too late, right? The accident's already happened, or they've already come into work impaired that day, and who knows what they've done or the mistakes they've made at their work. So I understand the rationale behind that, but I think there's still going to be issues where people are still coming into work, and we try to get people trained on reasonable suspicion so they can detect it, but nobody here, none of your supervisors are going to be like a trained drug recognition expert like police officers get, and you're not going to be perfect at detecting it. So some of it will go unnoticed too, if that's the only type of testing we do. And it doesn't serve to deter use to the same level as like random testing does. So people don't know when it's coming, they're less likely to. That threat of it happening at any point makes it less likely for them to use at all.
Yeah, but you can you can have zero tolerance. I know of a company, fairly large company in the last month, so we had a truck driver who drank during his lunch break and then proceeded to get in a terrible accident with a semi-truck. He was driving the semi-truck.
Yeah.
And of course, termination and everything else, but he did it between hours, in the middle of his day, even knowing they have zero tolerance.
Mhm.
So there's oftentimes where you can't predict the nature of the person and what they're gonna do.
Yeah, I mean, that's a good point. I mean, there's always gonna be people who do whatever, but I do think, I mean, there is evidence to show that policies and rules do influence action and at least help with that problem. I mean, yeah, there's always gonna be people who kind of go rogue and do their own thing. I know that some people are looking at, maybe we won't test for non-safety sensitive positions, or we will allow accommodations for medicinal use. All decent arguments for those as well, because we're saying, we don't care about your off-duty use, or for those non-safety sensitive positions, we're not as worried about that, because we're not as worried about hangover effects and coming into work impaired or something like that. But again, we've got that testing problem, right? We can't tell the difference between that off-duty use and the current use. So I think there's still a problem for the employers who are choosing to go that way. Some employers are choosing not to test at all. I would say not very many who have previously tested, but some are. And there's reasons for that, but I think you generally have bigger problems with production, safety, reputation, and things like that, if that's the way you go. Yeah.
If they refuse to test, do you have the right to terminate at that point?
I mean, it needs to be clearly stated out in your policy, especially for unemployment purposes, if you want to make sure they're not going to collect benefits on you for that. But yeah, generally it's justified to treat a refusal the same as a positive test, essentially, and terminate if someone refuses. Any other questions? Okay. I've touched on this question several times already, but basically, as long as my employee doesn't come to work impaired, what's the harm? And it's that testing issue. We just don't have it sorted out yet. And the last I read on it, I mean, the guy, he's clearly going to work really hard on it. There's a lot of money that would be wrapped up in succeeding to create that test. So there's a lot of incentive there. But me not being an expert in chemistry, I started reading about it. It was just like, wow, this is pretty complicated stuff. So I'm sure there's some practical considerations there that are making that a hard thing to test for. What about employees who have a medical marijuana card for a disability? Mentioned that earlier, no need to accommodate. But I would say that one thing we have to be careful about is we still have a duty to accommodate them for other reasons, or in other ways, I should say, rather than just off-duty use. And I would be very, very cautious if an employee came to you and said, hey, I have a medical marijuana card, will you accommodate this? I would be very cautious to terminate that person for admitting to off-duty drug use. I think there are some implications there under the ADA when somebody has a disability that make that a pretty problematic termination. So I suggest if that ever happens that you tell them, hey, we're not going to accommodate off-duty use unless you have decided to do that. But let's look at how else we could accommodate you at work, and then we'll still hold you to our normal drug and alcohol policy that's zero tolerance. Another consideration that some people have, whether it's you've got DOT drivers, federal contracts, subcontracts with various federal agencies, but there are lots of situations where you might not have an option to really have anything besides a zero tolerance policy. And so you need to look into that if you're the type of person who's doing that type of business. I've even seen some people who don't have government contracts, but they just have contracts with other private entities. And those entities say, if you're going to do business with us, you have to have a zero tolerance policy. So there's lots of reasons why your hands might be tied a little bit here, and you can't just be as flexible as you want. So what are most employers doing here? I would say most employers have not changed their policy really at all. The ones who have changed their policy that I've worked with, probably the most common change I've seen is just not doing the pre-employment testing, and then some people have switched to reasonable suspicion only testing. But most have just kept on with their zero tolerance policy, and they feel comfortable with that. We do need to, if you haven't done so already, look at updating our drug and alcohol policy. And I think some additional communications, I'll show you what I mean by that, are a good idea too, to just let people know where the company stands on this and clarify this for employees. Because employees, I mean, what are they reading? They're just reading the news that, it's legal. Now I can go down to the shop and buy some marijuana. They're not sitting here in trainings like this, and they don't really know all the nuances. And they might think it is okay under your policy without knowing that it's not. So I think if you haven't done something like that already, some additional communications are good as well. And I got a sample policy and a sample letter you can send your employees. So we'll talk about that and how those can be modified as well. Just have a summary of some of those options here. Allowing for medicinal, not testing in non-safety sensitive positions, only doing reasonable suspicion or post-accident, not testing at all. But I think we talked about some of those risks. Oh, that's one risk we haven't talked about yet, but it also, a lot of insurance policies will give you discounts for having a drug and alcohol-free, a zero tolerance policy. So you got to look at how that might affect your workers' compensation rates, your employer's liability insurance rates, maybe just your general operating insurance, and there could be some financial implications there as well. So definitely something to consider. Any questions about the different options and how you can, what your options are, I guess, to address this differently? Yeah.
Can you still call yourself having a zero tolerance on drug and alcohol, but still accommodate those who are doing that recreationally? Like, as far as maybe making it so where your drug policy is that under suspicion and what was it?
Post-accident?
Yeah.
Yeah. Technically it wouldn't be. And I mean, that's a term that's defined at the federal level. And so I wouldn't call my policy that if I was making some exceptions. I would, just call it our drug and alcohol policy. And you could still include language that we have zero tolerance for, every other drug that we test for, cocaine, methamphetamine, things like that.
I know, I'm not quite sure on their policy, but I know when I worked for Starbucks, they did no kinds of drug testing at all, but they still said we're a drug and alcohol-free workplace.
Yeah. I think that term has a specific meaning, and it's misused a little bit there, but I mean, I think I know what they're getting at. They don't want to go through the expensive testing and go through that, but they still want to make it sound like they're taking a really hard line stance on it. But you aren't if you're making those exceptions, and that's okay if it makes sense for your business, but I don't know if I would call it that, because it's not really what it is.
One of the
Yeah.
things that we're having problems with at our company is that we're a nonprofit organization, and currently we serve 190 adults with disabilities, where we put them into a workforce production manufacturing environment, and we are funded by the state. And so you have these caseworkers, and a majority of adults with disabilities are going to have different levels of drugs, and high levels to low levels that are still functional, and have the legal marijuana card. So it's okay to put them through the system without doing the drug testing. But yet, from an HR level in dealing with staff, it's the opposite.
Yeah.
And so there's this conflict that's occurring, and we don't know how, because we're funded by the state, and they're coming in one way, but.
Does the state say you can't drug test the people with disabilities that you place out? I mean, that's one thing.
If it's not, it possibly could be that it has to do with cost.
Yeah.
This is a long, since 1968 business, and so maybe.
Cost factor there.
Right.
Yeah, I mean, I think there's definitely still, and I don't know the specific details of, those state grants and what's allowed and what's not, and that would need to be looked into, obviously. But, I mean, to me, there's still a risk there, especially in a manufacturing environment, and I don't know the level of safety sensitivity that, for the type of work they're doing there. But it brings up a good point that we're not always just talking about illegal drugs here under our policies. You know, we need to let people know that even if you've got a valid prescription for something, but that drug can impair you, that's something that you need to be talking to us about, because we need to make sure you're fit for duty. And there's plenty of things that people are taking legally that aren't Schedule I at the federal level, like marijuana is, that obviously can impair you at work. I mean, you know, morphine and things like that are a lower schedule than marijuana. So people can take them legally, but obviously that, I mean, arguably probably has a greater impairment effect at work. And so, you know, are we gonna discipline an employee for having something that they're legally prescribed? Obviously not, but we do need them to communicate with us for safety and fitness for duty issues, and that's something that should be spelled out in your policy. Actually, we do have it spelled out in the sample policy I'm gonna give you. So I don't know the specific answer to your question because I don't know the details of your state funding, but I think you've got some of the same concerns as if they were just any other employee with you, and I think it's something that should be looked into because, gosh, if somebody did come into work and to one of those jobs impaired and injured themselves or somebody else doing something safety sensitive, yeah, there could be some liability.
But also protected to a point, from an ADA standpoint. So it's kind of a mess.
Yeah, it's a complicated one for
Yeah.
sure. Yeah, I would look into the details of how those grants are awarded. I think that will probably be a critical piece in answering that question.
Can you as an employer though ask an employee if they have a medical situation that they, you know, can you actually ask those kinds of questions?
A medical situation
Yeah, that we should be
requires-
aware of, that
requires the prescription. You can require them to disclose to you that they're taking medication that impairs. And generally with medical information, we want as little as possible as employers because we don't want to know more than we need to know. We don't want to have more information that we have to protect and things like that. But you can definitely require that and say, hey, you don't have to tell me the condition. You know, you don't have to tell me the name of the medication, anything like that. But you do need to tell me if you're taking something that has that warning label on it that could impair you. And it's just so we're aware of that issue.
and should that be written in your policy manual too?
Yeah, I'll when we look at the sample that I included, there's a sample paragraph that addresses that issue, so, yeah.
All this we're talking about in the manual, but if you haven't ever hired him yet, how much can you do in the application? Because it's great, but after you've already hired him, you spend all that time and effort and everything, and you don't have to figure out later.
That they have that medication. I mean, yeah, you're right, you definitely can't be asking that in the interview. You can ask people if they can perform the essential functions of their job and how they would go about doing it. And people, you know, I mean, the thing is, people don't have to tell you about disabilities and things like that in an interview. If you're really worried about it, sometimes people will do post-op or medical exams, and it could come out in there perhaps, because the doctor will ask if they're taking any medications that could impair them. And then depending on that, then you can look at, can we accommodate this or not, and potentially withdraw the accommodated. So that's one way of going about it that's in compliance with the law, but there's obviously a cost to those medical examinations, so that doesn't work for everyone. And you're right, some people will get hired without having told you.
How about just letting them know about your drug-free, alcohol-free policy
Yeah.
before they get hired?
Yeah, you can, but I mean, you can't, you know, there's nothing that says an employee has to disclose to you before they work that they have a disability, or something that would cause the need for that. And so you can definitely do that, and maybe some people will, but you don't, some people still won't, and then you're gonna be running up against that same problem.
Hey Ryan,
Yeah.
if you pre-employment a test and somebody tests positive for opiates or whatever, that's going to go out to a secondary lab, and it's also going to go to a medical review officer.
Mhm.
And that's when the conversation takes place about what they're taking and whether they're within, you know, the guidelines of their prescriptions.
Yeah.
So that gives you a better feel of, you know, what's happening.
And I guess
without
I'm,
you personally as the employer having to ask the questions, because that, you just farm that off on somebody else.
yeah, that's a good point, and I know that will alert you to some potential medications.
Yeah.
I mean, you probably know more about this than me, but there probably are some that could impair you that aren't gonna show up in the standard panel test though, right?
And it depends on what you're, you know, if it's safety
Yeah.
sensitive, we have different
Different panels,
based
yeah.
on what you all think might be a possibility and what's regional, you
Mhm.
know, what's going on regional here
Oh, yeah.
versus, you know, on the East Coast and stuff like that. So there's lots of different ways to get there.
Yeah, so that, I mean, yeah, that's definitely gonna help you in some regard as well then, but yeah, you,
But it becomes very expensive because you're looking at $75, especially if it goes to an MRO. And I know that in every company, corporation, costs is,
yeah.
you know.
I think that's $75 if you catch that on the fresh side,
Absolutely, I
you know,
agree.
and you spent 10
Yeah.
grand and then you had to wait 6 months because they did awful things and to get rid of them and
Yeah, no, I agree.
You got that nightmare going on the backside, so.
Absolutely.
Speaking of policies, just wanted to make sure we cover everything, but again, keep the questions coming because you're all asking really great ones. This is just some sample language. This isn't the full policy. That's a little more towards the back of your handbooks or your handouts. But here's a sample statement that could just be inserted into policy, you know, even your existing policy if you don't like the sample I gave you, to address recreational marijuana. And this would be a zero tolerance statement that we're making no exceptions to it. It could be edited if you were making some exceptions, but just some sample language to look at how you could put employees on notice about that. Do you have to include something like this? I would say probably not, because the language of most drug and alcohol policies I see is really clear in how they define controlled substances. It states that we're talking about illegal controlled substances. So that would definitely still capture the definition of marijuana at the federal level. But again, I mean, we're not just trying to cover our own butts with our policies and make sure we have the clear language that would stand up in court. I mean, our policies are also there to help explain issues to our employees. And so I think this is gonna be, there's enough confusion about this that you really should think about having a statement like this in your handbook. Yeah.
Do you think if you, as an employer, adopt a policy of tolerance with recreational marijuana, it might be better to say nothing about that tolerance than say that you tolerate it? I mean, for fear of fostering a workplace that may be perceived as one that allows their
It's a free
employees
for all.
to use
Yeah.
marijuana, putting in the trucks. I mean, what's your sense of that?
Well, I still think you have to address it to some level because even if you know, it's just like alcohol, it's used recreationally off duty. Maybe we don't care about that part of it as an employer, but we need to address the use and impairment, manufacture, distribution, possession at work, because those are still issues, right? And yeah, do whatever you want on the weekend, but don't start growing your plants in a closet, right? Yeah. But I mean, I want just to spell those issues out still, even if we do tolerate it to some level, like clearly what is still prohibited.
I was just gonna say, I know that you're not allowed to, or you can't right now, test for impairment for marijuana, but is there ways that you could be restrictive of saying it visibly impaired you, or if you're caught with it or something like that, then it's automatic termination?
I mean, you gotta be careful with visibly impaired, because again, like I was saying earlier, I think you want that test result, to be clear. But yeah, I mean, any policy, you can state that, yeah, like possession, manufacture, distribution, all those other things that we typically prohibit are still prohibited, and most policies do still prohibit that.
But you almost find yourself, say it as an employer, if you, and I kind of was chuckling, because if you don't talk about it, and you don't have that conversation with your employees, then couldn't you get yourself into as much trouble because you didn't say anything to them, or give them,
Well,
you know, have that dialogue, because they could say, well, you never mentioned it, or
I didn't know.
I didn't know, it was never discussed.
well, that's why I think you need to, I mean, you think of a handbook, right? And I mean, there's lots of things that people can do off duty, and we're not gonna, address all of those things. Like, say we necessarily affirmatively say what you can do outside of work. Like, you can smoke marijuana, but you can also ride horses and go to the movie and things. We're not gonna talk about all these things. But we do need to clearly spell out what we're gonna prohibit. Because if we're gonna discipline somebody for doing one of those things, even if we tolerate the off-duty marijuana use, I mean, that does have to be clearly spelled out. Otherwise, the employee very easily can make that argument that, hey, I mean, you didn't have a rule about that, and it's legal at the state level, so how did I know? So yeah, I think that's what needs to be very clear. And we don't have to affirmatively be like, yeah, go for it on the weekend. But yeah, what's not allowed at work needs to be
It's kind of like
clear.
an employee recently who wore their pajamas to work because Jessica didn't say they couldn't.
Just
So actually, at my niece's business, they did that. So they had to actually rewrite their dress code and specify no pajamas at work.
Yeah.
Because it didn't specify that.
I mean, I think you can, dress code, you could probably just say be professional, and that's probably
Yeah.
gonna, should reasonably interpret it to not include pajamas. Yeah.
I was just wondering on the testing, what's like time frame, the testing, like, if there's zero tolerance, they did it over the weekend, and it's Monday.
Yeah.
I mean, is it a month long, is it?
It
how long
can be,
is it?
there's so many factors, body composition, because it's stored in fat cells, and, frequency of use are probably the two biggest ones that affect how long it's gonna stay.
So higher,
But
the closer to that date that you tested them, or?
yes, even the metabolite will show higher, is my understanding. It can stay in people's systems and pop positive for, in the 6-week range, if we're talking about a heavy user. The occasional user who maybe doesn't have a high fat composition, it's probably gonna be a much shorter period of time, but still, probably early in the week if you tested somebody who used it on a weekend, they're probably still gonna test positive in most situations for that, is my understanding.
There is some distinction between occasional and regular use,
Yeah.
for sure, and that's the issue, that's really the problem, it's so variable depending on body comp, metabolism, the whole 9 yards, and that's why not only the gentleman that Brian is referring to, but there's also somebody in Canada trying to work through this too, and trying to, shake this down and bring some reasonableness to what's the end game, what's the number, what's the right number for everybody that's reasonable.
As far as a letter to employee, this is the stuff I'd want you to spell out, and the sample letter I'm gonna show you has all of that, but, just clarifying our company's commitment and why we have a drug-free workplace, what the law is versus our policy. It's, emphasizing that state law is not the only thing that matters, and then reminding employees of the expectations. So, if you guys wanna turn to the back, I don't have it on my printout, but towards the back of very last few pages, you'll see those sample policies as well as a sample letter that you can send out. So those are great things just to, steal, modify, use. If you already don't have something clear already in place, or if you like some of the language in there, go ahead and take any of that and use that for your own policies or communications. And then, just really quick, I want to wrap up here, and then I'll give you an opportunity for any more questions. But, next steps, I do think you should update your policy if you haven't already. And then get that communication out if you haven't already done something like that. I think whether, if you do any type of reasonable suspicion testing, and I do think at a minimum you should do that, you should also have training for your supervisors so they actually know what they're looking for. Most of us have seen people who are really, really drunk, and that's pretty clear to us, but good reasonable suspicion testing will help you out and figure out, what else to look for, or, what you're looking for when maybe it's not totally clear. When can we test when it's not totally clear, but we've got some good indicators of impairment. So that'll help supervisors so they really know what they're doing. Because we find that if supervisors don't have the training, they don't want to ask for the test. They don't feel comfortable. They feel like they're making this assumption. And they don't really know. And they're invading these people's privacy. So most supervisors say that. Even with the training, I think a lot of times they're hesitant. But I think the training helps them feel a little more confident to actually ask and go forward with that. And if we are going to make any deviations from a zero tolerance policy, get some consulting and guidance, talk about all the issues that we talked about today, so you kind of can weigh all the pluses and minuses and figure out which way you're gonna go there. What's gonna happen in the future? Hopefully we get the testing issue worked out. We don't know if Oregon might adopt an off-duty conduct law, and we're kind of waiting to see what will happen at the federal level. I do think it's gonna change at the federal level someday. I would be surprised if there was much of a push to change it anytime soon. I don't think that's something that, I think it'll take some time. Things just generally happen slowly at the federal level anyway, and that's not one that people are really like antsy to get changed. So that's all I've got. Any other questions or thoughts before we plug it in? If you gotta go, feel free. Thank you for coming.
I have one question. So, say you have like reasonable suspicion to suspect your employee like using drugs, alcohol on the job, and then you do like the on-the-spot drug test, and then they test false and everything, like they're just extremely or something. Are there any conflicts with the employer for
Not as long as you have that solid basis, that they were impaired, and you can articulate that if anyone ever asks the question. I mean, it is considered an invasive thing where you're taking something from someone's body. There's privacy concerns and issues wrapped up in that. But as long as you have enough of a solid basis, which needs to be like probably at least like 3 indicia of impairment. If you've got that, the fact that it all came back positive or a negative test wouldn't be an issue as long as you also didn't take some other action against them, employment action.
Now,
Yeah.
because the testing's not 100%, whether they had it before or they just had it, how much can you use social media and stuff? If you're pretty sure that they are using
You
it.
just can't.
So,
It has to be on
but
site.
if it's obvious that they are posting that they're using
Yeah.
it or whatever.
I would say for the most part you can't use it because it does have to be current impairment. So unless the employee gets on, it's 12:09, I'm so high right now, something like that, and I'm at work, so where it's clear. I mean, that I think you actually could use because it's their own statement and it's during work hours. But outside of something silly like that, it's probably not gonna be a statement that shows current impairment at work, and you're not gonna be able to use it.
I just wonder, I have a business owner whose employee was obviously coming off of a hangover while on a workers' comp claim.
Well, hangovers, yeah, we talk about that in reasonable suspicion training, but I mean, when people are hungover, alcohol, there's a lot clearer evidence about this, but often people are still impaired. I used to do Dewey hearings as an administrative law judge, and definitely saw those people who got picked up at 6 a.m. on their way to work and blew .15. And so I'm just hungover. I mean, often hungover is impaired, and so that's same thing. Marijuana, though, we don't have good levels established for that, though, unfortunately, and what that would look like. But if they were acting impaired, you've got a zero tolerance policy, and then they test positive for marijuana, you're going to be justified in taking action in that
There's
circumstance.
just something to think about. We have a client that just opened their shop recently, and it happens to be a marijuana shop. And they did ask us to drug test their employees, and their policy says they want to know and want information sent out on non-negatives for anything except marijuana. Everything else they want to know about, and they will prosecute. Dismissed from job, not even hired, the whole 9 yards. But if it's marijuana, just set it aside. We can do that.
Yeah, I mean, you have that option too, and a lot of
Run
people.
the flavor however you want.
Yeah, a lot of people don't care as much about marijuana, but
They
yeah,
don't.
we sure would care about if someone was using meth, or
Right.
something like that, so you've got a lot of options.
So as an employee or employer,
Yeah.
even if you allow, so like if you're doing a social event, if you allow employees to have cocktails during an event, after hours or socially, you're legally liable for the time, because you've allowed it, right? So even if it's a social event after hours, that it's reflective of your business.
If you, that's an arguable one, but if you sponsored a party that was just some wild free-for-all, and you didn't, encourage people to drink with moderation or call cabs or things like that, yeah, you could definitely have some liability. I think most companies who have parties now, they set up cab services, or they, put limits on things, so it, they are limiting that potential liability. But yeah, you actually gotta, I mean, all people do those things because other people have been sued and they're reacting to that, so,
Yeah.
yeah. Anything else? Cool, well, thank you all for coming. It was great showing.